webinar, Joint Lease Advisory and Building Surveying. I can see the numbers of people joining rising, so we'll get started just with an introduction whilst the last couple of people are joining. You have me this morning. My name's Amy Durkin. I'm Head of Lease Advisory at Vickery Holman. I've been working in it for about 6 years and get involved with all matters that our team advises on. And then also with me this morning, I have James Vowles, who's the Head of Building Surveying. Also been at VH around 5 years, and again responsible for all the many services that building surveying provide. We're Vickery Holman, in case you didn't know, and we've got the building surveying and the lease advisory team here this morning. And a little more information about what our respective teams do. With lease advisory, we're looking at anything to do with leases and rent usually. So that includes rent reviews, lease renewals, lease surrender negotiations, market rent valuations in all the main commercial sectors. And then with building surveying, again, big department, cover off all sorts of things from the pre-acquisition surveys, schedule of condition, dilapidations and project management, more specific things like that. Our webinar today is looking at lease renewals and dilapidations. We're going to be using a few case studies, particularly having a look at the importance of timing, because that's quite crucial in both of our areas. And then there'll be some time for questions after that. You may have used looked at a webinar on Demio before. Just a few things to point out. We've got a chat box that you're more than welcome to pop things in there, and you can pop questions in there as we go. We'll have a look at the end. We also have a poll that's just started, which you can have a look at, which is to do with dilapidations. And then a little bit later, we'll have our handouts put out on here for you to download. So that's that for Demio. So let's get started. First of all, we're going to have a look at what is a lease renewal. And essentially, it's a new lease agreement entered into between a landlord and a tenant after the expiry of the original term of the lease. It's important to establish if the lease in question is inside or outside the Landlord and Tenant Act 1954, as the process differs slightly in each case. So with inside the Act, which traditionally would be the majority of leases, it falls within the 1954 Act, and therefore when the lease comes to an end, the tenant is protected by law, has a legal right to renew. And to gain protection under the Act, it must be a business tenancy, and this will have 6 basic elements. So there must be a tenancy, the premises must be used for a business, the tenant must occupy the property or a large part of the property for at least 6 months. The tenancy must not be excluded, which we'll move on to in a second. And finally, there must be a competent landlord. So a business that's got a lease inside the Act, the lease does not terminate with the effluxion of time. So the tenant is entitled to continue holding over, which means they can remain in possession of the premises until either the landlord and tenant serves a notice to terminate, more on that later, or they enter into a new lease according to the provisions of the Act. If a landlord doesn't want a new lease, they can terminate the lease under the 1954 Act, but there are only 7 grounds to do so. And these range from various forms of the tenant breaking a lease, breaking covenants, to more landlord-driven reasons, for example, redevelopment or owner occupation. And if the landlord is successful ending the lease under landlord-driven grounds, then they must pay compensation to the tenant based on the rateable value of the property. Conversely, when you're looking at leases outside the Act or excluded from the provisions of the 1954 Act, you will know simply by reading the lease, it will clearly state that this lease is outside provisions of sections 24 to 28 of the Landlord and Tenant Act 1954. If the lease is outside the Act, there's far less security. The tenant does not have the right to renew, and the lease will end with the fluxion of time on the lease expiry date. The tenant therefore doesn't have the right to remain in possession after the lease has expired. So whether the lease is inside or outside the 1954 Act, there is a lease renewal process to follow. It's good to bear in mind with renewal negotiations, they can be a more delicate process than perhaps with rent reviews, as the tenant has no obligation to stay. And also there's both the rent and the further lease terms that can be reviewed. The lease renewal triggers a negotiation of what the rent in the new terms should look like, generally reflecting the market conditions at the time. So the lease terms that are up for negotiation will include the length of the term, whether or not there's a break option to be included, whether this would be landlord only, tenant only, or a mutual break, and possibly if there's any penalty or other conditions that need to be satisfied to option that break. There'll also be the presence of rent reviews, whether how long between rent reviews there will be, and will it be based on open market rents, or maybe it'll be indexed. And then some other lease terms which are generally not so often negotiated but are still able to be changed at this point would be the repairing obligations, which James will come on to shortly. Assignment and subletting conditions, whether this is particularly difficult or if there are any other restrictions to do with assigning your lease. And of course, the security of tenure. At this point, it is possible to renegotiate whether a lease is inside or outside the Act. I'll explain the process further when we're going to look at our case studies a little later on. But for now, I will hand you to James, who's going to take you through an introduction to dilapidations.
Good morning, everyone. Before we get into the case studies, it's Amy mentioned, I thought it'd be useful just to have a reminder of sort of an overview of the lapse and the type of leases. So what are dilapidations? To put dilapidations into simple terms, they represent exit costs for a tenant at the end of their lease. These costs are typically attributed to putting the property back into its original pre-let state, i.e. repairs or reinstating any cosmetic alterations. A schedule of dilapidations is presented to the tenant by the landlord, which can often come as an unwelcome surprise, and it is not uncommon for disputes to arise. Typically, a landlord will serve the following types of schedules of dilapidations on a tenant. So during the lease term, an interim schedule, as we said, is generally served mid-term and will only deal with serious breaches like a cause and diminution in the property value or a threat to health and safety. An interim will not usually contain costs against listed breaches, as the intention is for the tenant to implement the works rather than claim damages. Then there is a terminal schedule, which is traditionally served at the end or in the last few months of a lease to avoid a tenant's defence against forfeiture proceedings. The terminal schedule should be served in the last 3 years of a lease originally granted for more than 7 years, but by virtue of being terminal, it will not usually be served until the end of the term. A terminal schedule will detail all breaches and will include costs for compliance on the basis settlement will usually be achieved as a damages claim, i.e. financial. Once the lease ends, the only option for settlement is damages, whereas up until expiry of the term, the tenant has the right to implement the works listed in the schedule. Terminal schedules, their content and the conduct of the parties in agreeing damages claims are now governed by the Dilapidations Protocol, which came in under the Civil Procedure Rules. And then finally, a final schedule can be issued. The content is the same as a terminal schedule, but issued after lease expiry and typically includes the full quantified demand for other losses that could be incurred, such as loss of rent, rates, insurance rent, and service charge. All these schedules should be served by solicitors at the appropriate time to ensure that they are served correctly and on the correct people. So then we look at the types of leases. It is important for landlords and tenants to fully understand the leases to which they have signed up to. As a reminder, the types of leases are full repairing and insuring, known as FRI. This is the most common type of repairing liability within a commercial property letting. FRI means the tenant is responsible for maintaining, repairing, and insuring the entirety of the property from the moment the lease starts. And at the end of the lease, they will be expected to return the property in no worse condition than they took it on. The landlord will usually arrange the building insurance for the premises and charge the cost back to the tenant. Effective full repairing and insuring lease, known as effective FRI. This does not differ hugely from an FRI lease, however, is most commonly found in multi-let buildings where there are shared communal areas and or shared external elements to the building. The landlord will charge the tenants a service charge, which will generally cover the upkeep and maintenance of the external and communal areas of the building, as well as the building's insurance. The tenant will be responsible for paying a proportion of the overall cost for these services under the service charge, and will usually only be directly responsible for arranging maintenance and repairs to the internal elements of their demise. And then the final type is internal repairing and insuring lease, known as IRI. This is less common within commercial property. This type of repairing liability means the tenant is only responsible for the upkeep and repairs to the internal elements of their demise. For instance, if there is a roof issue, this would be the landlord's responsibility to repair and incur the costs. Generally, rents on an IRI lease will be higher than a full repairing to compensate the landlord for the extra liability they have. It's important to understand the repair clauses within the lease, as these can be limited by schedule of condition, or certain elements of the building, i.e. the roof, may be removed from tenant responsibility for maintenance and be retained with the landlord. Therefore, it is important for both parties to read their leases and to understand the repairing clause to identify what they are responsible for during the lease term.
We're now going to take a look at a couple of case studies and how you can see how the lease renewal process and the dilapidations process can often work together, or certain situations where one service has a much heavier workload. So this first one, scenario one, a modern industrial unit with a lease expiry early next year. It's inside the Act. So from a lease advisory point of view, a section 25 or 26 notice is likely to be needed here to bring the tenancy to an end and begin negotiations. Some further points in this situation that we might need to consider is that the rent will likely increase because it's an industrial property, and on the whole that market's doing very well. Also, the tenant has already requested that they would like a break option where there wasn't one before. So we'd start the lease renewal process here by firstly reading the lease and preparing a lease summary, and then inspecting the property, measuring, looking for all areas of industrial property that have note when looking at comparable evidence. So the eaves height, the general quality inside, any external yard space as well, all important. And then we would research and analyse our comparable evidence to determine market rent. So comparable evidence is really, really important for both rents and also for looking at new terms. So in this example, where the tenant is looking for a break, possibly in year 3 in a 5-year lease, we can look at other transactions to see if this has been agreed there, as to work out whether this would be an appropriate thing to have. And if we couldn't find any transactions that had a break in that area, then potentially an upward adjustment in rent might be needed if they did want the break there, to reflect a shorter term than normal. So after we've done this, we then report our findings to the client, and our recommendations as to how to proceed and what the best new lease terms we could expect to negotiate. And then with their agreement, we then begin negotiations with the other side, and see these through to conclusion.
So in this case study, we have a property that is a modern industrial unit with a 5-year lease expiry due in February 2025, and we look at this from the landlord's perspective. The landlord should review the lease, particularly for any time-related clauses, as notices for items such as reinstatement of tenant alterations may need to be issued in order to protect their position. The common mistake is that no notification is issued to tenants to remove alterations, and this should be duly considered in order to protect the position of the landlord in the event that the tenant does not review the lease. The landlord should then arrange an inspection of the property to ascertain its current condition and the breaches of the lease, particularly the alteration and reinstatement clause. Alterations need to be carefully considered, and any alterations or unauthorised alterations noted and included in the schedule of dilapidations. There is a risk that these alterations could inadvertently form the demise during the lease renewal negotiations and form part of the future demise detailed in the new lease, which may mean the tenant may not need to undertake costly reinstatement works at the end of the new lease. The schedule of dilapidations will determine the landlord's next steps. They may be content for the dilapidations to roll over into the new lease and be remedied at lease end, particularly if they are minor in nature. Alternatively, if the landlord is keen to ensure their property is maintained, as part of the negotiation of the new lease, they may decide to get the tenant to undertake works within a set time limit, or enter and undertake the works and reclaim the costs as damages. This will be down to the solicitor to revise on the exact wording of the lease clause and to confirm the process should the landlord wish to enter the property to undertake the works. In all these cases, we strongly advise that legal advice is obtained.
Moving on to a different kind of property there, scenario 2A. This one's an older property with a lease expiry and also outside of the Act. Providing the landlord is happy for the tenant to stay, then the same process around researching and negotiating the new terms and rent is carried out, the same as before. Just one consideration where this is an older property is finding comparable evidence that of similar properties, or being able to apply appropriate adjustments for perhaps having to compare to a more modern or purpose-built property. If the expiry date passes or is close to passing and the parties are still negotiating, it's sensible to try and get a tenancy at will in place, as this would allow the landlord to continue accepting rent and continue to negotiate new terms. Accepting rent when outside the Act lease has expired could lead to the tenant gaining security of tenure. So care should be taken, and say a tenancy at will in place would ensure that that the negotiation can carry on and new lease can be put in place as soon as possible.
So in this case study, the property is an aging industrial unit with a 10-year lease expiry approaching, and the tenant is proposing to stay. We'll look at this from the tenant's perspective. The tenant should undertake a dilapidations liability assessment, which is a comprehensive report in which the property is inspected to assess the condition and to provide budget costs for repairing, disrepair, redecoration, reinstatement and compliance with statutes. that would typically be included in a landlord scheduled dilapidations at lease ends. The purpose of the assessment is to assist with the tenant strategy. It may determine whether a tenant will stay and manage the dilapidations liability during the new lease term, as the liability may be high, and by staying and undertaking the works, they will receive the benefit of any works undertaken. Likewise, the tenant may have received a costed schedule of dilapidations from the landlord, setting out their position, and the tenant may consider it is more cost effective to stay and manage the dilapidations liability during the new term rather than incurring a significant exit cost in one lump sum. If the tenant decides to stay, they may consider undertaking the works prior to the lease renewal negotiations commencing. This means that they will not be under pressure at the commencement of the new term to complete works required by the landlord. They may also be able to control the cost better through procurement and other remedies such as recovery of VAT that the landlord may not benefit from, and this may be considered a more cost-effective solution. It is unlikely that a new lease will remove the current dilapidations liability, and work may need to be completed. We are seeing a number of cases where landlords are inserting clauses into the new leases which would enable them to undertake the works if the tenant has failed to do so. If the landlord is undertaking the works, the tenant will have lost control of the procurement methods, contractors used, and the methods in programming of the work, which all could result in additional costs than if they had undertaken the work directly themselves. They will need to carefully consider this as part of their strategy moving forward. Once the tenant has signed the new lease, they should be looking to undertake a pre-planned maintenance schedule of the property. This is a report based on the condition of the property over a 5-year period, which is costed to give an indication of expenditure and when the works may need to be undertaken. This will allow the tenant to budget for this work, and by undertaking works, it will hopefully reduce the cost of repairs, as items that are repaired before defects become more significant will be cheaper to maintain in the medium to long term.
In this final scenario, we have the same property as before, and this time the tenant is going to leave. They've told the landlord that they're off. For the lease advisory team, in this case, we have limited involvement as there's no new lease to agree. However, James and his colleagues will have a lot more involvement in a situation like this. I'll let him tell you all about it.
Yes, so as Amy said, in this scenario, it tends to hand over to the building surveying team to advise landlords and tenants. The scenario that we're going to run through is looking at this from a tenant's perspective. So again, it's the case of an aging industrial unit and the tenant has decided to leave at lease end. On making the decision not to renew the lease, the tenant needs to carefully consider their exit strategy. They should undertake the dilapidations liability assessment mentioned in the previous slide, or they may already be in receipt of a costed schedule from the landlord. Through the analysis of the dilapidations liability assessment or terminal schedule of dilapidations that received from the landlord, the tenant has decided the liabilities are already high and may potentially get worse, so the best option is to terminate the lease and not to renew. If the tenant has decided not to renew and terminate the current lease, then the full dilapidations process will start. If the tenant has been organised, they would have undertaken their dilapidations liability assessment and considered their strategy for exiting the property. As tenants, they may have undertaken a proportion or all of the works and then potentially look to finalise the remainder of the claim by financial settlements. In addition, there may be other strategies applied, such as knowing the landlord's intentions for the property. Is the landlord choosing to demolish or extensively refurbish, meaning some of the breaches will potentially be superseded, or have undertaken a Section 18 valuation, which is a specialist valuation in relation to diminution in value, which may cap potential repairing liabilities. This is something that our specialist valuers can advise on. and should form part of the tenant's strategy and due diligence in relation to their exit. Once the lease has been terminated and the tenant has vacated the property, they will lose control of the process for undertaking the works. At that point, the landlord could undertake the works. However, as mentioned earlier, their procurement method may be different to a tenant's. They may not be able to reclaim VAT. And by the landlord undertaking the works, the landlord would have potentially crystallised their losses, which in theory makes a claim for damages easier. You are also potentially likely to incur additional costs, as you will need surveyors to review the landlord's works to ensure there is no betterment or supersession, to ensure that it has been undertaken in accordance with the breaches listed in the scheduled dilapidations. Therefore, it is important as tenant to be considering your strategy early and not leave it to the last months of the term to consider your exit strategy and potential dilapidations liability.
Moving on to the importance of timing now, and this is a theme that comes across in both of our areas. There's a number of deadlines to consider. For the lease renewal process, the main ones will be the service of the Section 25 or Section 26 notices. So the Section 25 is a landlord to a tenant, and the 26 is a tenant to a landlord. And these must give a maximum of 12 months and a minimum of 6 months notice for a tenancy to end. So ideally, these would be served well ahead of the lease expiry date. And if these are served after the expiry date or within 6 months before, then it will have the effect of prolonging the lease, the term certain essentially, so that there is time to negotiate between the parties. The lease advisory team in most cases will have already done their report on the property for the client, and therefore can advise the solicitors on the terms that should be included within that notice. Although these notices are not required for outside the Act tenancies, we'd still advise landlords and tenants not to be complacent with this sort of lease and to start talking about possible renewals, certainly 12 to 6 months in advance. If the landlord wants to oppose a Section 26 notice from a tenant for a new tenancy on the grounds discussed earlier, then they've got to serve this notice of opposition within 2 months of receiving their notice, or else they'll have to move to negotiating the new tenancy. And then finally, a less common notice seen by the lease advisory team is the Section 27, which is given by the tenant when they wish to leave the property and they're holding over, and they've got to give 3 months for this one, showing their intention to leave.
Yes, as Amy said, the importance of timing is everything, and that applies to dilapidations as well. So looking at timings from a landlord's perspective, landlords need to be reviewing the leases for their properties within the last 12 months of the term. This is to determine if there are clauses that are time critical that would affect their strategy, or notices that need to be served to protect their position, i.e. instructions to remove alterations from the property. There may be no indication that the tenant will renew the lease, but your strategy in relation to dilapidations may determine how they approach a lease renewal. You should consider instructing the surveyor to inspect the property, and as the term will be in the last 12 months, to ascertain its condition and any unauthorised alterations to the building before agreeing on whether to issue a schedule of dilapidations upon the tenant. From a tenant's perspective, if you're in the last 12 to 15 months of the lease, you should be considering whether to renew or terminate, and therefore you should undertake a dilapidations liability assessment. The purpose of the assessment will assist with your strategy. It may determine whether you stay, as the liability may be high, and then phase the works over the new lease term to ensure that you receive the benefit of the works undertaken, or through the analysis of the assessment, you may decide that the liabilities are already high and may continue to get worse. So the best option is to terminate the lease at that point and settle a dilapidations at lease end. The important thing is, do not leave these considerations to the end of the term. Tenants who do not consider their dilapidations usually get a nasty surprise.
Great, thank you, James. That brings the webinar or the information part to a close. Just a couple of points here about LinkedIn. We're very active on LinkedIn, and we like it if you'd like to sort of put a post on LinkedIn about this webinar and how you found it. Also, we'd be really interested to hear what other topics you might want webinars on, either from Lease Advisory and Building Surveying or any of our other teams. We're always looking for ideas of what to put on next. So if you did have any ideas, please let us know. That would be great. And just a reminder, this video will also be on YouTube, probably in the next couple of hours, to look back on, share with any colleagues that aren't here. So yeah, more than welcome to go and have a look. There's quite a big video catalogue on there of other webinars as well. Okay, we'll move to some questions. Just going to have a look at the poll first, actually, as we'll put your answers. So the question was, how familiar are you with dilapidations? And we've got 54% of answers a little, and 38% of answers quite a lot, and then smaller amounts on not at all or expert. So that's great. So I hope that, yeah, James certainly been able to offer a bit more insight into that for everybody. So we've got some questions. James, first one is for you. Should all leases include a record of condition and layout so that there are no grey areas when it comes to determining the extent of dilapse?
It's a good question. In terms of the layout, that's important to get the layout, is some sort of lease plan added into the lease so that the demise is clear at the start. That's always useful from an alterations perspective of what's been undertaken, particularly on leases that have been in place for a long time, because quite often if landlords change, people aren't aware of what the layout of the lease was at the start of the lease term. In terms of schedule conditions, they tend to be part of the negotiation. So as a tenant undertaking your due diligence, you may find that the property isn't in a great condition. So you might decide that as part of your negotiations with the landlord at lease for the new lease. This is not referring to a lease renewal. This is when someone's identified a property right at the start. Is it a schedule condition could be put in place, particularly if it's in a poor condition. Some landlords won't accept that because obviously they will then be liable for a proportion of that, because it will mean that the lease will require the tenant to put it in no worse condition than the schedule condition. So yeah, it's always worth trying to negotiate that at the start of a new lease. The only thing with the schedule conditions that we find from a dilapidations perspective is that if they're good quality schedule conditions, it detail all the elements of the property and all the defects that are present. They do act as a good defence, but we do see some schedule conditions that are just a few random photo shots that actually don't offer much defence, because usually it's missing the photo of the key defects that's been listed in the schedule. So I think if you are going to have a schedule condition, then it really needs to be a good quality one, and appended to the lease with a full suite of photos that are clear and easy for everyone to be able to look at when they're on site.
Great, thanks, James. Next question here: to what extent do terms in a lease dictate the terms of new renewed lease when inside the Act? Good question. So generally, when you're looking at an inside the Act lease that the court might eventually end up being able to decide the terms for you if you can't negotiate, then they would take the current terms as the basis of the new lease, and therefore if there was no want for either party to change anything, then that would be generally what would be put forward. So that's the standard there. But as I said before, if either party wants to make a particular change to any area, then they can do that, and looking at evidence and coming up with reasonable reasons why those terms would be in there. If that can be negotiated and agreed, then that's kind of how you get to change leases, change terms in lease if either party particularly wants to. Okay. The next one, if you don't do a tenancy at will, what extra rights does the tenant have? So this one, we always go on the assumption that a tenant being in an occupation after expiry with an outside the act lease may get security of tenure. Don't ask me to quote it, but there are cases that prove this. So hence we're always very cautious and ask that either negotiations are done suitably far in advance, that the lease is done and signed before the expiry date, or there's an agreement in place, say tenancy at will, which will allow negotiations to run on slightly beyond the expiry date to allow for more time. Question for you, James. Would the landlord also carry out their own Dilaps report prior to agreeing a new lease with the existing tenant?
Yes, so as I said in the presentation, is the key thing from the landlord is for them to ascertain the condition of the property. So they probably have to work on the assumption that the tenant may leave. So it's always sensible to get a schedule of dilapidations produced and served upon the tenant, even if the tenant and landlord are discussing a lease renewal. So likewise, if a tenant is doing a dilap assessment to make their own decision, the landlord should also have a schedule of dilapidations put in place. And again, it may also affect the tenant strategy, that when they receive the schedule of dilapidations, it may determine what options they choose moving forward.
Great, thank you. Next question, what is required to ensure a tenancy at will is in place while negotiations continue? So we would usually ask the client's solicitor to draft and put a tenancy at will in place. They're fairly simple documents that basically state the current terms will continue until a point. Either party can terminate these usually fairly quickly. So it's still quite a flexible arrangement. I believe you could do your own as well, but that's something that we usually again put to our the solicitor working for our client to arrange for us. Next question. As a landlord, can I include a clause for a tenant to give notice to quit if outside the 1954 Act? I suppose you might be able to, probably a question for a solicitor. I think, so I've lost the question now, let's put it down. I mean, usually the tenant will have to leave on the expiry date regardless, so it's probably not particularly necessary actually. It's more the tenant knowing that date is in place, and you as a landlord knowing that they are supposed to leave on that date, and to make sure that there's no crossover with collecting rent after that date or getting that tenancy at will in place, as we've said. Right, next one. Can a lease inside the Act be periodic from month to month with a stated notice period, e.g. 2 months, or does that create difficulty with possible right to renewal? Yeah, usually those short-term tenancies are nearly always outside the Act. Technically, if you've got a lease of 6 months or longer, and they then got fairly flexible break options, potentially that lease would be inside the Act. But more often than not, if it's one where they only give 1 month's notice for the next month, then that's usually outside, because as you say, right, you don't usually want an occupier in that situation with the right to renew indefinitely. Next question, I think this one is for you, James. Will delapse obligations move onto the tenancy at will if negotiations of the new lease break down?
Good question. I'm assuming that's between the end of the tenancy at will from the end of the current lease to the start of the new lease through the new lease renewal. Well, the dilapidations aren't going to go away, because if there is no new lease, then the dilapidations process at lease end will come into play. If there's a new lease in place, then those will roll over into the new lease. I would imagine, and this would be for the solicitors to revise, but there would probably be some wording within the tenancy of will to ensure that there's no grey area or loophole that would enable dilapidations to disappear. But either way, there's also remedies for the landlord if the tenant disappears and decides not to renew, or for the lapse to roll over. So in theory, they should all be covered off, but probably most landlords would like to ensure that that's covered in the tenancy as well to protect their position, and that would be for the lawyers to revise on.
Yeah. Okay, brilliant, thank you. Next question on EPCs. Knew we were going to get a question on EPCs. Hot topic. Who would have the liability to bring the property up to a level E EPC standard, and how would that affect a delapse claim? So, question for both of us there, I would say. Generally, landlords seem to have the responsibility for putting that property into that level, and certainly within leases, there's usually a lot of clauses around the tenant not being able to do anything that affects that rating, not being able to get their own EPC sorted for sort of bargaining reasons and things like that. So generally, my understanding is it's the landlord. James, what would be your comment on affecting dilapidations, bringing it up to standard?
Yeah, I think at the moment there's a lot of discussion going on about this, and I don't think there's a definitive answer, and it will probably be something that will be determined by the courts going forward. I think at the moment there's usually a lease clause that states not to affect the EPC. So, for example, if the EPC was E at the start and the tenant has done something to drop it down to an F, then the tenant would obviously be required to bring it back up to that minimum requirement. And then there's this grey area about if the landlord has to bring the building up to a standard to an E to make it lettable, are those works going to be so significant that it's going to render a lot of the dilapidations claim superseded by the works being undertaken? So yeah, there's some grey areas. I think there's a lot of people waiting for case law to come on this, but I think at the moment we haven't seen too many landlords acting for tenants trying to get the tenants to upgrade the building to a minimum E. I think it's one of these areas that no one really wants to go to at the moment without the case law to back them up. It's
no, thank you.
I think it's a case that it's going to evolve over time and develop, and then once there is the case law, everyone will have an understanding of how best to proceed with it.
Yeah, definitely. Yeah, thank you. Next one also for you, James. Is it straightforward for a tenant to offset any improvements to the property against the dilapidations claim from the landlord?
Well, I suppose it's difficult. This is always a grey area, and a lot of tenants will believe that they've made improvements to a property, but actually what they consider to be improvements may not actually make it lettable in the future. And the requirement is, for example, in a warehouse, to return it back to basically the shell of the building, and the tenant may have put offices in that they may consider as improvements, but actually the landlord may want them stripped out. So I think, again, it's very important for when tenants are considering these works that they carefully consider this, the extent of the works they're going to undertake, but they also need to be mindful that not all landlords will consider their works as an improvement, and through the license to alter or through the lease clause will require it to be stripped out at the end.
Yeah, brilliant, thank you. Last two questions then. Is holding over where leases are both inside or outside the Act, or just one of these? I mean, we tend to use that term for both, but it would be inside the Act where the tenant is officially holding over on the same terms as before. If they're in occupation on outside the Act lease after expiry, they're technically not supposed to be there, but I guess, yeah, we tend to use that term for both, but it's really sort of referring to the inside Act lease, I would presume. Okay, and then the last question, at a renewal of a 10-year lease, can the landlord insist on the same length of term, and would the court support this, or can the tenant object to this using evidence to demonstrate shorter lease terms are more in line with market conditions? Yeah, this is what you come across quite commonly at the moment, with a lot of 10-year leases coming to an end. And yeah, you're right, that the market isn't there for that length of term. So yeah, it's about finding evidence that supports a different lease term length. And if you couldn't negotiate that, if your landlord was still insisting that 10 years is there, and you went to court and you did expert reports, that would form part of what you were arguing, that this length of term is not correct anymore, and here is my 8-10 comps where a shorter term is the reality. And that would definitely be taken into account when you're looking at terms. It's the basis of what the lease was, and the terms in there is the basis of it, but it is after that down to evidence and the expert opinion on what is most appropriate at the time. Brilliant. Well, thank you very much. Some really great questions there. Just a reminder, we've got our handouts now on the handouts page that you can download. And that brings us to a close. So thanks everyone for listening. Hope you enjoyed it. Thank you, James, for your input. Really great stuff there on Dilapidations. And yeah, we look forward to seeing you at the next webinar, whenever that will be. Keep in touch, keep on LinkedIn, and yeah, hopefully we'll see you all soon. Thank you very much.